Long Island Backstory with Chief Correspondent Gary Jacobs.
Good afternoon, everybody. I'm Gary Jacobs. Welcome to another edition of Long Island Backstory, rated the top TV show here on Long Island by everybody in my family. Today's guest is Chris Henry, who found me on Facebook, I don't know, through Americans for Legal Reform, saw the Long Island Backstory show, and started telling me about what he had going on in his court case, and I found him to be very, very knowledgeable. He did a lot of research. Unfortunately, as I tell a lot of the judges, the problem is when you screw people for so long and keep them in court for such a long period of time, you create the monster, because these people get very educated, smart people, they get educated, they spend a lot of time listening and reading, and now you're creating somebody who can fight you, and that's what they did in this case with my next guest, Chris Henry. Chris lives in New York. He has a career in finance where he worked for several of the major institutions on Wall Street for approximately 12 years. He is subject matter expert on finance and taxes for the IRS and the state of New York. He filed for divorce in Manhattan about 10 years ago, and this is where the story begins, like many of them here on Long Island Backstory. He suffered the nightmare of family court and the child support collections unit. As a result of his experience with the courts and child support, he's filed lawsuits in the Southern District of New York, which is Manhattan. He has 2 lawsuits filed against judges, one for Judge Tandra Dawson. Is she watching us today, Phil, on Facebook Live? I don't know about that. Hopefully she'll watch it on TV or YouTube. She's in the Supreme Court, as well as support magistrate Paul Ryneski. Am I saying that right?
Yes, that's correct.
Okay.
Ryneski, Paul Ryneski.
Okay, and New York State itself. All are being sued under the category Title 4D USC 1983 Act for conspiracy and fraud under the Social Security Administration Title 4D. This starts in 2010, where his first judge, Judge Kaplan, would not deduct his mortgage payment before calculations of his child support. The same year, another party filed an appeal against the same judge, Judge Kaplan, and the judge's decision was overturned. This case is Chiara versus Chiara, Khaira, if anybody wants to Google it. The support magistrate is a non-judicial officer, and therefore he or she is subject to the law or will suffer the consequences, hopefully, of Mr. Henry's lawsuit. So, Chris, very nice to have you here on the show today. Thank you for coming out.
Thank you, Gary. Thanks for having me. Just to be brief, yes, I was a financial advisor on Wall Street, was happy. I lived myself for about 5 years, owned my own apartment. I got married like everyone else to extend my life, and this is where it began. I decided to file for divorce, and I filed my paperwork, and it was great. I came home one day, and there is an order of protection for me to leave my apartment. Now, this is my apartment. I was ordered to leave. As the police officer says, it's required by Manhattan that an order of protection that you should leave. So this is what starts my case. So while I was going through that, they decided to give me to a support magistrate named Paul Ryneski. So he calculated child support. So while he's doing that, he refused to remove the mortgage. Obviously, I know that I have paid a mortgage. It's obvious that is the case. And he refused to, but at the same time, the judge on that case, which is Judge Kaplan, she got overturned for not doing that. And as Gary says, the case is Chiara versus Chiara. It's a landmark case in New York. You must calculate mortgage and housing payment before child support. What happens is all the judges calculate child support first, then they take out it. But this is where the nightmare begins. While all this is going on, a convicted felon moved into my apartment. Now remember, I'm removed from my apartment fighting to get back in, and he orders a personal security license from the state of New York. The state of New York actually issued him a license with my address on it. Now, what's wrong with this? The state of New York knows that it's my address because I pay taxes on it and I pay mortgage. They also know there's a convicted felon that spent time in their prison. They know he's a convicted felon. But here's the thing. New York says you're not allowed to give personal security or even armed security to a convicted felon. So I'm not saying his name because he's unimportant to the story. So what's the problem? So I went down, asked for help, and this is where it begins. Judge Dawson said, oh, well, I'm not about to change anything because why? Judges have absolute immunity.
But you're saying that, so the convicted felon that he moved in, is he a new boyfriend of your?
He was a new boyfriend, yes.
So not only that, so he was with your child then?
Yes.
It's even more scary.
Right. But again,
And you haven't even permanently been kicked out at this point,
I have
correct?
not been permanently kicked out, and all this started snowballing. Now, I went to the state at first and says, wait a minute, you issued a license against a private residence, which I own. I'm not sharing with anyone. And they at first didn't have an answer for it, and they said, go back to the judge. So they went back to Judge Dawson, and all this time she's just trying to throw me in jail. Created all these issues to, again, try to remove me from the equation. So
Well, that'll shut you up.
it did. I really was shocked. But then I decided to ask for help from attorneys, and they were no help. I went to the self-help agencies in the Supreme Court. By the way, they mostly support women. There are very few agencies for men to get help. So I decided to do the research on my case. Obviously, if the audience think that this is right, that the state can literally move me out of my apartment, and the judge who orders it uses absolute immunity in which to commit a crime, I'd love to hear the vote on that. So that's what started. So I started doing the research. So while doing the research on, obviously, in my constitution, I found a letter from the Department of Justice dated March 14, 2016, 2 years ago. And what was striking about the letter was, and I'll paraphrase pieces of it, the first thing it said was, this is the letter, right? This letter should be provided to every judge in your jurisdiction, which is appropriate for training judges in areas discussed below, which is constitutional right. And this is what they're asking. You create a bench book, you assist judges in performing their duties lawfully and effectively, and we hope that they will work directly with the Justice Department so that they do not violate an individual rights. Now, in court, I asked the other side, did you receive this letter? Of course, they said yes. So here's something else as part of the letter. You know, in New York, they tend to incarcerate you for non-payment. Everything is, we're going to throw you in jail for the payment. In the same letter, it says, and I'm quoting from the letter, it says, to comply with the constitutional guarantee, state and local courts must inquire as to the person's ability to pay prior to imposing incarceration for non-payment. Think about that. All those child support orders where people can't pay, they're supposed to follow this department letter.
And conventional wisdom in court is, well, if you have a court order to pay, you're presumed to be able to have the money to pay. This says no, that's not the case. You have to prove the inability to pay.
That's correct, Gary. It says you have to prove the ability to pay. It further went on, it says, failure to pay, fines and fees, and the case is called Turner versus Rogers. It says, holding that although there is no automatic right for counsel for the contempt hearing, you must for child support. Again, it says here, child support in the letter, that due process is violated when this hearing does not take place. What does that simply mean? Meaning, if the person says they can't pay, the first decision by a judge is not to throw them in jail and say you get 6 months or you come up with a check. Now, further on in the letter, which was striking to me, and I brought this to Gary's attention, it says at the bottom, in the court system, if the court system receives federal funds, then these practices under Title 4 and 6 of the Civil Rights Act is violation of your 14th Amendment. So why is this letter important? This letter was delivered to all the attorney generals across the country. In my case, they acknowledge receiving it. These are spelled out in detail what not to do. Ask anyone in the court system. How many people have been arrested for child support? How many people are arrested for parking tickets? This letter, I think, is critical, and anyone who has a complaint should file this letter.
All right, so tell us about the main issue with child support and 4D, which people who are watching, they don't understand. They say, well, the judge is just looking out for the best interests of the kid. And judges, we all believe, even though it's not the case and most of us know it, but they're supposed to be impartial and have no incentive one way or the other in a case. In fact, even a notary public can't have any financial gain or interest if they notarize a paper. A judge certainly shouldn't have any interest. Yet we find out about Title 4D and how that works. So please explain to the audience what you learned about Title 4D and child support.
So further in the letter, and as well as over the internet, the Title 4D was a replacement for the child support program. The Title 4D has two provisions in it. One, it's for children and needy family. The second was to reimburse the state. Here's where the problem is. That means the higher the support order, the more reimbursement comes to the state. Well, that's a conflict of interest, because what are you going to do? You're going to try to get as much child support, which is what Ryneski did in my case. He removed the mortgage payment, because if he had included it, then obviously this child support order would be much, much lower, almost 50%, but he did not do that. The other problem with the case is that this has been tried all over the U.S. In Holberg versus Holberg in Minnesota, in Carey versus Hauser, all the judges have come back with very simply this. A child support officer is an Article I hearing. It's not a judicial function. Therefore, in New York, where they give these support officers absolute immunity, is constitutionally wrong. And to prove it, the Title 4D program is administered by the Secretary of the Treasury. Well, the Secretary of the Treasury is one, Article I or from the executive branch. If you read the section on that, it is administered by an Article I executive, not a judicial officer. Now, isn't that interesting? So how can a non-judicial officer get absolute immunity? If that's the case, then the janitor can try a child support case and get fully immunity, because he's a non-judicial officer hired by the state.
And people talk about these officers, and what they don't realize is a lot of times your attorney will say, well, we have to consent to it, to letting this person hear our case. First of all, you don't have to consent to anything, because if you had to consent, then it would be an automatic appointment. So what they do is they make you sign a piece of paper, not a piece of paper, they make you sign an order agreeing that you agree to have this person hear your case. And I don't remember the exact wording, but you're basically saying we're letting this person act as a judge. You're saying don't do that. I tell people, be very careful about doing this.
Well, the issue is it's a question of permission. You have to give some permission for your rights. You have to fight for your rights. You can waive your rights, you never lose them. So what they do is they disguise it by having a child support hearing in a court. Just because you're in the courtroom building, it does not mean you're in an Article III, and I don't want to get into what an Article III is, but understand this. Absolute immunity is reserved only for judicial officers. A child support hearing officer, when you read their employment, they're employed for 3 years as a non-judicial officer. I believe it's Section 655 of the New York Employment Code. How can a non-judicial officer now has absolute immunity when they're not? So in the Holberg versus Holberg case, the justice is saying, no, you cannot do that. Harlow versus Fitzgerald said very simply this: only judicial officers get absolute immunity. Bottom line. So in New York, they get away with it, and I'm not going to say they should or should not, but read the law.
So tell us about your lawsuits that you filed, because a lot of people come and they say, I want to sue my judge, I want to sue the hearing officer, I want to sue this one. And the first thing everybody says is they have immunity, judicial immunity, and then if they don't, but if somebody else, they'll extend it to quasi-immunity. They have all these words to say that we're going to screw you when you go to court.
Right.
So what did you file? And listen, even if you're going to lose, there's something to be said for fighting back.
Right.
I mean, I hope you don't lose. You're in court right now. You're surviving it. But there's something to be said for fighting. And as you told me, Gary, if everybody would file what I filed, they'd have to pay attention to it. One person, two people, we could throw you out easily. But if 100 people followed you, 200 people followed you, we can get somewhere. So tell everybody about what lawsuits you filed. And this is all public record.
This is all public record.
They can Google it. Go to Pacer.
Pacer, yep, it's public record. In fact, anyone come to the hearing. A group of Yale Law School students was in one of my hearings. Basically, it's this: you're not a lawyer. You're just an individual fighting for your rights. So what happens in New York? They tend to disregard your case based on motion to dismiss or Rooker-Feldman.
Which Rooker-Feldman, without being a lawyer, is basically that you have to exhaust all your remedies in the lower court before you can go to the federal court, which is you're trying to play. Correct. In the federal court. You have to exhaust it, and it's who is to say, what is exhausting it? You'll be dead. You'll be 60 years old.
Correct.
Before technically, because as we all know, there's really never any end in family and Supreme Court, because you can always file something somewhere else, right, and then they'll drag you on, and it'll be a moot before it's done. So, but this is what I've seen a lot of people. They say, "Well, you didn't." I've been in court for 10 years. How many more years before I exhaust everything?
Right. So So basically, it's very simple for individuals, right, not attorneys. They will say that you need to exhaust state rights. The Supreme Court says that's not true. You can petition the court at any level. That's guaranteed by the Constitution. But in terms of Rooker-Feldman, yes, you have to exhaust state right. You don't have to. Title 42, 1983 law that says you can bring a case. Only thing you're required to do is two things. It has to be done in the color of law, and there has to be damages. In my case, taking me from my apartment definitely is damages.
Absolutely.
So the next thing is take away my mortgage, so the higher mortgage payment is also damages. So when I got there, the key thing to make sure that you include in your lawsuit is this. You're not an attorney, you're an individual fighting for your rights, and those rights can only be exercised in district court. So I basically took the state of New York, Judge Dawson and Paul Ryneski, directly to court. And of course, the automatic is, well, they're absolute immunity. Fine, I don't have a problem with it, but you must prove it on the record. Because here's the classic thing, Haller versus Fitzgerald, that says, fraud is not a judicial function, so therefore, it is not protected by immunity. So now we have to go to what is called the heart of the case. And the heart of the case is this. If they were to win this, that means tomorrow morning, every support officer in the state of New York will remove housing payment, therefore increase the Title IV reimbursement. And New York alone will get about $1.2 billion in child support payments over the next 5 years. Can you imagine that? It's crazy, but it is done. So that's the problem. And the other thing with the lawsuit, that you're not going to get any help. All the self-help folks will not help you because they're part of the system. The lawyers will be very happy to talk to you, but they refuse to file cases against judges. Because why? Because those are the very same judges they need in order to advance their careers. So you'd have to go this alone. What I'm asking everyone is, even if you know you're not going to win, file. You have a right. Under the Constitution, you have a right, what they call redress your harm. Gary, what more you want to say?
So Chris, is there any way to fight child support? And I'm not saying fight it like I don't want to pay child support, they have no jurisdiction, but to fight unreasonable child support that's just overwhelmingly burdened. It puts people in jail because they can't afford it. Is there a way to? This agency is such a behemoth, and the system is just set up to make people pay and bleed you to death and fill the jails with the people who can't. Is there a way to fight it?
Yes, there is a way to fight it. The first thing to understand is, do not equate your child's welfare with the child support system. The child support system is a Title 4D on the Social Security Act. Do not confuse them. I hear this all the time. So this is not about your children, it's about reimbursement of the state. So the first thing you do is find out if you're married, and I know it's expensive, you probably want to move to an Article 3 court, which is Supreme Court. I know it's expensive, but here's what happens. You cannot plead constitutional rights in an Article 1 court, which is child support court. So if you're married, they do not have jurisdiction. And I know there's ways to get around it, but the key is they do not. For instance, they can't do divorce and they can't do full custody because they're Article 1. Second, if you're already in the system like most people, because the first chance is what they do is they try to get you in. You either force you to get in, threaten you to get in. Once you get there, you now have to understand that you are guilty. So what you're looking for is fraud. Remember, fraud is not a constitutional right. So you're looking for fraud. So here's a couple of ways to look for fraud. Coercing you into signing documents that you should not sign.
Well, go back on that, because that's a big point. Because a lot of people are coerced. They'll say, the attorney will come out if you have it and go, the judge told me you have to sign this agreement.
Right.
What do you mean I have to sign it? If I have to sign it, let the judge order it. And happens all the time. People and the attorneys do it. They say the judge said you have to sign it. You don't have to sign a goddamn thing.
Correct.
If the judge wants to order it, let him order it, and I can appeal it.
Right.
But if you sign it, then you lose all your appeal rights because you agreed to it.
Right.
So that's called fraud, though?
That is fraud. It's called abuse of process or abuse of power. You can never be forced to sign something that you do not understand. The problem is when you're in Article 1 court and you have an attorney, you lose your rights to argue that if the attorney does.
Because also the attorney should have explained it to you.
Should have explained to you. But if you're there by yourself, you have a right. Now remember, your constitutional right does not work because you're already guilty in Article 1 court. So what you're going to do is step through this very closely. If they miscalculate the child support, fraud.
And this happens a lot, by the way. Be close. There's the thing with the MTA where they take out your pension money, and that should be deducted. You're mentioning the mortgage.
Yes, and this is most critical. In New York, we tend to pay high rent, which means our rents tend to be about 50 to 60% of our salary. Because of the Khaira versus Khaira, and like I said, I stumbled into that.
Say this case again. Spell it.
Khaira versus Khaira, Khaira. I stumbled into it because it was my judge that got overturned on that. She would refuse to take out the mortgage payment, and the appellate court says, no, you have to, because it's called double dipping. So you take that out first, then you calculate the child support. What happens is it lowers your child support order across New York. New York got wind of that and decided, well, we're just going to ignore it, but it is an appellate court case. So that's the first thing. Then, if it's inappropriate, the law clearly says, go back and recalculate if it's inappropriate. That is in the law.
Inappropriate meaning what? Meaning there's not enough money left over?
There's not enough money left over even to buy a cup of coffee.
And this happens a lot.
Right. So that's the fraud. The second fraud is if your children are taken away from you. That's really more fraud. So under Article 1, the real target is not constitutional charges, it is fraud. And as you can recall, Harlow versus Fitzgerald, fraud is not sanctions within the Constitution, period, because everyone is entitled to what? A fair trial. So you look for those frauds. Other thing, if you're coerced by the police, I'm going to arrest you because you did not pay. I just read to you DOJ letter. What did they say they're supposed to do? They're supposed to have a full hearing. They're supposed to go through the steps and do everything in their power not to incarcerate. That letter, again, was distributed to all of the attorney generals, who then is supposed to disseminate it to all the judge. So if you're in a hearing and you go, did you get the DOJ letter? And they said no, provide them a copy.
So how do people get the letter, people watching? What would they search on Google?
They could search for March 14th, 2016, Department of Justice letter on incarceration. And it will come up. It's about 9 pages long, and that's it.
Okay. So let's say they do all this and they ignore it all, which is common, right?
Right.
Then you can go ahead and sue the support magistrate?
Well, here's what happens. And here's how they get around the law from Article 1 to Article 3. The rule in the Title 4 is that you must have what is called a judicial hearing. A judge must decide that. So what they do is they force you to go to the appellate court and call that judicial review. Well, if you have absolute immunity and you're a sitting judge, you can sign your own orders. I don't need to go to the appellate, so this is how to get around it. But that's why the Holberg versus Holberg case says, wait a minute, you are practicing law. You're in Article 1. No, and they struck it down. In Kerry versus Hauser, they did the same thing. No, the Secretary of the Treasury manages Title IV, which is executive power, which is Article 1. That's it. There's nowhere in there where it says a judicial officer is involved. So threat of incarceration. Now, what New York sometimes do is, well, you violate a court order, which is a payment. You're saying I owe a debt. No, you violated a court order for a payment. No, I owe a debt. See, they changed the language such that, violating of a court order, by the way, is subject to arrest. So that's how to get around it.
Right, because we're not putting you in jail for the money. We're putting you in jail for violating the order, which was to pay the money. But if you pay the money that we're not putting you in for, then you can get out of jail.
Right. Now, there are people right now in the bottom of Manhattan in the jail. I think it's about 122 people that are there for either mostly child support or not paying parking tickets. Why do you have nonviolent people locked up in jail for a year because they can't pay a debt? In Kerry versus Hauser, they said that child support is a commercial debt. It falls under, again, commerce, Article 1. There's so many places where Article 1 shows up. I don't know why anyone would think that a hearing examiner is an Article 3 judge with immunity.
Right. So as a tax professional too, because you do that also, what about child support and taxes? How does that work? Because I know the law just changed this year on child support.
The law changed, and unfortunately they did not touch that area. In fact, they did not touch any of the family areas. For example, child support is not deductible either to the payer or to the payee. However, alimony was adjusted, but that is still in place. So here's the thing. So you end up getting tax-free money. You're giving tax-free money to the government. That is why they want the maximum amount collected from you, because you can't write it off to the federal government. Because here what would happen. If you write off child support to the federal government, then the federal government has what is automatic audit. They love to say that the states are immune by 11th Amendment immunity. Not when it comes to federal program. There are 6 federal programs in which the federal government has what is called automatic. You cannot use the 11th Amendment. One is the Disability Act, next the Veterans Act, next the Social Security Act. But then in Texas, there's a case that ruled that, automatic, you're exempt, 11th Amendment cannot be used in any federal program. If I can pick one, I can pick another one. A Social Security Administration, which is where the Title 4D, again, it's SSA Title 4D, it falls under Social Security Administration, which means 11th Amendment immunity does not apply. Pearson versus Ray, if the amendment cannot be used in order to commit a fraud. That's it.
Great. Well, Chris, thanks for coming on the show. I really appreciate it, and hopefully your lawsuits, will survive and become
Thank you.
case
I
law.
hope so,
But
too.
the key is fight back.
You have to fight back. Whether you win or lose, you have to fight back. Because what has happened is it's a $3 billion a year business. It's greater than Twitter. Tax-free.
Yeah, you got to fight back. And I say, listen, don't just roll over. You'll feel better about yourself. And listen, who knows who's going to win. But if they know you're a fighter, sometimes it puts them on edge. So I'm Gary Jacobs. Thank you again for joining us at Long Island Backstory. Before we leave, we have an extra minute left. I just want to introduce somebody from our crew tonight who's been working really hard, Phil Antonucci, who's doing our Facebook Live and also our portable, I don't know what you call a portable camera. So Phil, come on, don't trip on your camera there. Can you come behind the camera, Phil? Well, you got to turn around so we can see you on the camera.
Oh, okay.
Yeah, come around so everyone can see you.
Everybody.
Come on, Phil. Phil's a big part of the show, so
Take the camera down.
Phil's doing all the Facebook Live, and we've been trying to step that up. So Phil, come.
Reply to that. Well, guys,
And he does the replies, so obviously it's not magic. Well, Phil, come around.
the letter that you were referencing, if you can put it on your LI Backstory Facebook page.
Okay.
Everybody was.
Okay, a lot of people looking for the letter on the show because we're also broadcasting on Facebook Live. We'll ask Chris to post that.
And also,
on the,
I'll
Backstory.
post my email, which is chrish289@protonmail.com.
Okay, we'll put that in the bottom of the screen,
Yeah.
right?
And also, what about Robert Griebesland wanting to know what about add-ons?
Add-ons is a made-up category which the states are allowed to do under the Title IV program. You need to watch those. Those could creep up higher than the actual payment. In fact, most of the arrears comes from that. By the way, the arrears, the state gets to keep that. It's not part of the entitlement program. I would love someone to send Gary the last fiscal audit from the Title IV program to New York State to see exactly how much they have received. It would be astonishing.
Phil, come on, you got 30 seconds left. Get up and come over here, please, Phil. This is Phil Antonucci, and he's been doing our camera for, 3 years, over 100...
5 years now.
5 years now, over 100 episodes on Backstory, and he started doing the Facebook Live about a year and a half ago. And as many of you can see, just on Facebook Live, many of the shows end up with over 2,000 views. So Phil's a great addition.
Got branched out onto more media though.
Very good. And then we have Donald Caulfield. Come around, Donald,
Don.
over here. Don's wearing his best clothes tonight for the show. And I hope we can have room for you in here too, Andy. And I just want to get the whole crew out here. And this is Donald Caulfield, and he's on our 4K camera. He also does the timing. And Phil, he does the countdown, and he does do the thing when I run out of time. Do it, Don. Come on, do the wrap up. That's the wrap up. And then when I start running out of time, and he starts going crazy, do the face. He starts getting crazy. And then we have Andy, who not only does our sound and our camera setup, but he also does our editing. Does an amazing job. And even though it's a half-hour show, Andy ends up spending an hour and a half to 2 hours editing all the shows and making it look good. Unfortunately, he hasn't figured out how to press the skinny button to make me look like I lost 50 pounds, and he hasn't figured out how to make it look like I have a full head of hair, but we're still working on that. And but I appreciate all these guys and everything they do to make the show come out the way it is, because I'm not talented. They're the talented guys. So thanks, guys.